Afternoon, everybody. Thank you very much for joining us. We'll just wait for a moment while the numbers rise as more and more people join the call, and then we'll get started. I'm just going to say in advance that it's very windy where I am here in North London, so apologies in advance if you can hear a lot of stuff clattering outside my window or a dog barking. Hopefully it won't sound too loud. Okay. So we're very pleased here at the 3 Million to be hosting this webinar for pre-settled status holders. It's the third webinar of this sort that we've held with Chris. The first one was in the summer of 2023, and then there was another one in the summer of 2024 when the Home Office introduced a number of changes to the settlement scheme. And because there's a lot of uncertainty still, and we know that there are a lot of questions in people's minds, we decided it was a good idea to hold another one. And we're very pleased to have Chris Benn with us once again from Seraphus, and a leading expert on citizens' rights issues and the EU settlement scheme. I'd like to say thank you as well to those of you that have submitted questions in advance, which many of you have done. We are hoping that Chris will be able to answer many of those questions, though we're also conscious that there will be some questions that we simply can't answer at the moment because there are things that just aren't even known at the moment, probably not even by the Home Office. We're also conscious, though, that there will be, no doubt, some of you who weren't able to send your questions in advance, and probably some of you will have questions that occur to you during the course of this webinar. So please do go ahead and use the Q&A function there on your Zoom screen. What we will try and do is answer some of those questions during the course of the webinar, but there will, I'm sure, be some that we're not able to get to today. And so rather than answering them in writing in the chat, what we're going to do is to compile and send out a Q&A document after the webinar has finished, addressing as many of those questions as we possibly can. And we'll make sure that that document is sent out to all of you who've registered for this evening's event, and anyone who had registered but wasn't able to attend. So Chris is going to answer questions for around an hour or a bit longer than an hour. And then we were hoping our colleague Sarah Maramag was going to be here. She's unable to be here in the end, but luckily our CEO at the 3 Million, Andrea Dumitrake, is going to be here to speak to you about our newly formed peer support group and what you can do to take action if you want to urge the government to act reasonably and fairly when it comes to considering the issue of excessive absences, which I know is one of the things that has brought many of you here today and about which many of you have very legitimate questions. So I'll spend a few minutes at the start providing a bit of background and a bit of a general update. We will finish at 7:30, and we are recording the webinar as well. And when we send out the Q&A, we'll also send out a link to this recording. So please feel free to share both the document and the link to the recording to anybody who you think might benefit from it. We are conscious that there are a lot of things that remain unclear about the situation for pre-settled status holders, in particular how they're able to move to settled status. As I said earlier, we won't be able to answer all of those questions, and what we are doing at the 3 Million is pushing for the Home Office to grant all pre-settled status holders settled status. But a little bit then about the different issues that we're going to cover today. So the first issue is that of extensions. So as a bit of background, in 2023, the Home Office started extending pre-settled status by 2 years for people who were approaching the expiry date on their status. And then in September last year, they changed that 2-year period to a 5-year period. And the reason that that decision was taken to automatically extend status for pre-settled status holders happened because of a court case that was brought by the Independent Monitoring Authority, also known as the IMA, against the government, that the 3 Million and the European Commission were involved in through influence through intervening. And that court case challenged the requirement that the UK had in place for pre-settled status to make another application in order to not be left in a position where they didn't have status or leave to remain. And the earlier webinars that we did in 23 and 24 looked at that in a little bit more detail. So if you're interested in going back and looking at those, they can be found on our website. So until recently, the extensions have been made around a month before somebody's pre-settled status was due to expire. In recent weeks, they've started doing that extension a little bit earlier than that to create a little bit of wiggle room. So if you have pre-settled status, as you approach the expiry date, you should receive a notification to tell you that your status is going to be extended. It's really important to bear in mind that those extensions are issued automatically. There's no caseworker involvement. No Home Office decision maker is looking at your case or your circumstances. It's an automated process. And what that means is that the Home Office isn't checking to see whether someone is eligible at the point that the extension takes place for settled status, further down the line. So getting an extension doesn't necessarily mean that you'll be eligible for settled status after you've had 5 years. And that's something I know many of you have queried. There are lots of different reasons why someone might no longer be eligible. For example, if they get sent to prison for a long period of time, or for family members, it might be if the relationship with your EU sponsor has come to an end, that could impact on your eligibility as well. And a very common way of falling out of scope or not being eligible is by being absent from the UK for too long. And that's something that there's been a lot of confusion around. So I just want to provide a little bit of information about that as background. So pre-settled status and settled status automatically are lost if you spend 5 years outside of the UK. And for pre-settled status holders, it used to be just a period of 2 years that would mean you'd lose your status automatically, but that changed in May 2024. But it's really important to bear in mind that that doesn't mean that as a pre-settled status holder, you can stay outside the UK for anywhere close to 5 years without that having any impact on your eligibility. It's just that you haven't automatically lost your status. But how long can you spend outside? So for pre-settled status holders, you can be absent for up to 6 months in any 12-month period, not in a year, any 12-month period. When they say 6 months, they mean 180 days. So anything beyond a 180-day gap might be seen as breaking the continuity of your residence. And they're really looking at who lives in the UK and who doesn't really live in the UK. So for example, if you're away for 80 days between October and December 2024, and then you come back and then you spend 110 days out of the country from April to August, that would still count as more than 6 months absence because it's within a 12-month period, even though the absences were spread over 2 calendar years, 2024 and 2025. And we've got an absence calculator on our website that will help you to see whether you've exceeded that 6 months in a 12-month period. So if you're in any doubt, please do go onto our website and use that tool. But there are some exceptions to that rule around absences. So you can have a single absence of up to 12 months for an important reason. And the Home Office has set out some examples of what those important reasons might constitute, but it's not an exclusive, exhaustive list. It could be because you are pregnant and going through childbirth. It could be if you're serving a period of compulsory military service, or because you have a particular work posting that takes you out of the UK. It could be if you're abroad and have a serious illness. But it's really important to bear in mind that whatever the reason is, you'll be expected to provide evidence in support of that. Excuse me. So, for example, if you are studying abroad, you'd need to provide proof of that. If you've got an overseas posting, you would probably need a letter from your employer. there are various different pieces of evidence that you could use. It can also, these absences can also relate to COVID, and I think many of you have come across this guidance that the Home Office has issued as on that point. And if you're absent for COVID reasons, it normally means something along the lines of you being ill with COVID yourself, or being quarantined, or caring for a family member who's sick with COVID themselves. It could also include circumstances in which you're studying at a university, and because of the pandemic, your university classes all went online and your university recommended or told you to go back to your home country and continue your studies from there. There are lots of different circumstances that might fall under the umbrella of the COVID absences. But the Home Office will look at any of these lengthy absences and will decide if, in the Home Office's view, they're justified. And so that's why it's really important that you provide evidence to explain your circumstances. And if you have had an excessive absence, or you think you might have been outside the UK for cumulatively too much time in a given 12-month period, we very strongly urge you to seek individual legal advice. The sooner the better. Even if you're not coming to the end of your pre-settled period, or you've recently had an extension, if you think that this is going to be an issue for you, we would say get legal advice as soon as possible. Cerifest provide very good legal advice. We also, on our website, have another list of recommended advisors, and we're able to signpost you to advisors, some of which provide free legal advice for people who can't afford it, but do get yourselves tailored advice in these circumstances. And it's just final point on that is that it's really important also to know that you cannot start a new 5-year period after the 31st of December 2020 and build up your residence again. So what I mean by that is if you were in the UK before the end of 2020 and then you had a long gap and came back in 2021, you can't start your 5-year period of pre-settled status in 2021 in the hope that you will be able to obtain settled status. There will be an issue with your continuous residence that will have to be addressed. And that's why we're saying it's so important to get legal advice if you find yourself in what could be a precarious position. But again, Chris is going to hopefully answer some questions on that in a little bit. I just want to speak briefly about curtailments and automatic upgrades to settled status, because those are two of the other big issues that people are talking about at the moment. So in terms of automatic upgrades, the Home Office started in January of this year upgrading EEA nationals from pre-settled status to settled status. And in doing that, they use automated checks of government records, which basically means if you've got an HMRC record because you've been paying tax for 5 years, or you've got a record with the DWP, they will be able to use your national insurance number to see that you've got a very clear presence in the UK. And in those cases where it's very clear, they'll automatically upgrade people to settled status. Later this year, they're also going to start doing that for non-EEA family members and for people under the age of 21. And where there is no clear record, we know that they're looking at ways to use travel border data to upgrade people where they can, but we don't really know the details of how that's going to work yet. What we would say though is if you know that you're eligible for settled status and you haven't had an automatic upgrade, continue to apply, because not everybody will be eligible for the automatic upgrade, and those people will need to apply directly. And then finally, on curtailments, before I turn to your questions, this is a big concern that a lot of people have, and it's something about which there's still a lot of uncertainty. The Home Office is, however, considering what to do when they believe that someone no longer qualifies for status under the EUSS. So, for example, when they think there is a break in the continuity of residence, and they may at that point start to take away people's status. The Home Office doesn't seem to have decided how they're going to be doing this, but whatever steps they do take will have to be proportionate, they will have to be fair, and they will have to give people an opportunity to respond to the suggestion that they've broken their continuity of residence and are no longer eligible. And they'll have to give people an opportunity to provide evidence to counter that. And if a decision is taken to curtail somebody's status, they'll have to also give people a right of appeal against that. But again, if you're worried about any of these issues, get legal advice early on so that you can be prepared as possible. At the 3 million, we're very worried about potential repercussions of this, and we're urging the government to take a compassionate approach and to grant people settled status on the 5-year anniversary of their pre-settled status grant. But we need your help to make the case for this, which is why we would really urge you to report concerns that you have through the Report It system that we have on the 3 million website. We'd also recommend that you file a complaint or log your story with the IMA, the Independent Monitoring Authority, who are also very eager to hear about the difficulties that people are encountering. Contacting your MP can also be a good way to advance your own case. Sometimes, not always. It depends, of course, on how helpful your MP is. But it can, at the same time as advancing your own case, be a very good way of raising awareness with politicians about the sorts of difficulties that people are facing. And we've also set up, as I mentioned earlier, a peer support group, which Andrea is going to tell you about later, which you can get involved in as well if you want to help to advocate for a fair and proportionate approach to what is undoubtedly a very difficult issue. So I'll stop there. And I will turn to you, Chris. Well, I'll ask questions that you've all submitted in advance, yes, and so turn to Chris for his input and his expertise. So Chris, the first questions that we have that I'll put to you are about this rule about absences. And we had one from somebody called Agnieszka who wanted to know if somebody who's working abroad for a UK-based organisation can include time spent away from the UK but still working for a UK-based organisation count as time spent in the UK?
So first of all, just thanks very much to the 3 million for inviting me, and thanks for everyone for joining. A real pleasure to be able to join this session. It's really important. It's a very, very complicated subject, as Kezia has just set out for us. So hopefully I'll be able to provide some help and answer some of these questions. So the answer is, like, time spent in the UK, it means physical time spent in the UK, and so being linked to a UK organisation but not physically in the UK wouldn't change the nature of that to mean that you are considered resident. Obviously, Kezia has talked about the kind of exceptions to the normal 6-month residence rule that applies throughout the 5 years that you're building up to settled status. And if your UK-based organisation posted you overseas for up to 12 months, then that would be part of your 5-year qualifying period. You wouldn't have to kind of make up any extra time. It would just be part of your 5 years because it's accepted as an important reason to be away from the UK for up to 12 months. But if your sort of question is, I've been posted like overseas by my UK organisation for 3 years, is that going to work? Then no, because you're away for too long in that situation, and it can't be considered to be UK residence. Sorry, Kezia, you are muted.
I muted myself. That was the dog. I muted the dog and myself at the same time. Yeah, thanks for that, Chris. And so can you just confirm then that would apply to people even if they were still receiving an income from on UK payroll, receiving the income in the UK, even if they had a tenancy in the UK or something, would it still not count as residence in the UK?
No, so the scheme is based on it's done on physical residence, like that's how it's calculated. So having sort of documentation linked to the UK if you're not here is not deemed to be physical residence. I think we're sort of aware that there could be some limited scenarios where if your HMRC record is active and you are not, but you're not actually in the UK, that could lead to the Home Office drawing a sort of false positive that you are in the UK and eligible for settled status. So potentially that could happen, and the Home Office may even give you settled status based on that false positive. And if that happens, then that in theory, that's, you're not being asked about your situation, so you're being given that. But that will be very limited. But for the purposes of people thinking about what do I need to be proving, it's about when were you physically here? If you have been absent for an extended period due to COVID, due to another reason, employment, etc., what do I need to show the Home Office to show that I've maintained my continuous residence for the 5-year period I need to rely on?
Thank you. A question that we had from Adam related to the way that the 180-day absence is calculated. Adam wanted to know what would happen if a person had several shorter absences that added up to more than 180 days, but they all related to the same important reason, because the guidance is that there is, one important reason. If there are lots of different smaller pieces of absence, how would the Home Office treat that?
Yeah, it's a very good question, and obviously a very practical question, because the rules unfortunately operate in a binary way, which is when you have this sort of extended absence, if it's due to COVID or for something else, and then it's referred to as a single absence. And so obviously, if you have multiple entries, even for very short periods in that time, that isn't a single absence. The language does not support that being a single absence. And so the rules would say you cannot meet the continuous residence. Now, however, what you mentioned a really important thing about sort of proportionate decision making, and how the Home Office looks at these more sort of complicated situations of absences. And I think anyone logically would say, if you're making proportionate decisions about whether someone has maintained their residence, someone who's had an absence that doesn't exceed 12 months, that is for a valid, important reason, but they have some entries to the UK for short periods during that time, proportionately, you would be saying that has to be justifiable, because otherwise you're coming to a sort of slightly absurd outcome compared to the person who just had one single absence. And so I think that, so if someone presented me with that and said, should I apply for settled status? I would say no, because the rules operate in a binary way. And so if you cannot meet the single absence criteria, then you can't get settled status based on the rules. Down the line, when your situation might be looked at by the Home Office, will you be able to sort of proportionately justify your situation? I would then sort of say, well, I would hope so. So it's really tricky, because you're sort of saying, well, you can't necessarily apply for settled status in that scenario because you can't meet the rules. But whether you should lose everything connected to all your rights under the settlement scheme, clearly that would seem to be disproportionate. So I would hope that you won't be losing your rights anytime in the future. But that's where you talked about earlier. We're going to have to come back and fill in some of these gaps at a later time, because right now we just don't know what the Home Office policy on this looks like. So I have a lot of sympathy with the situation. Can the person meet the rules as they stand? No, not in that situation.
And so would you suggest then that somebody in that situation just waits with their extension of pre-settled status until a point at which the Home Office contacts them?
Yeah, until we know what the Home Office intends to, whether they intend to look at these situations, how they're going to sort of apply a policy of proportionality. Absolutely, because that's all you really can do, because you know that you can't meet the rules, and the way the scheme operates is, if you don't meet the rules, you don't get upgraded to settled status. You don't lose your pre-settled status, to be clear, if you don't meet the rules for settled status. But to me, if you applied right now, then you'd be setting yourself up to fail. So there's no point in you applying right now. And what we need to do is wait to understand what the policy and proportionality looks like. Look, how does the Home Office intend to engage with people, so that they can explain why this situation has arisen, and so a proportionate decision about their situation can be made. yeah, very much, I'm afraid it's a wait and see right now.
So Adam had another question that relates to that, which doesn't necessarily only apply in this sort of circumstance where someone's had multiple absences for the same strong reason. But he's asked, would it be better to proactively address absences and to put in your justifications for those absences in your settled status application, or would it be better to wait and see if the Home Office contacts you to ask for further clarification and evidence?
Yeah, so I think that this will very much depend on whether you can sort of meet the rules, like I've just been talking about, like this idea of binary rules. So if you have an absence of up to 12 months because you were ill or your family member was ill, and it's a single absence, so we know that that would be justifiable. It fits within the rules. So if you were applying for settled status, then you would want to, you're asked in your application, do you have any absences that go over 6 months? So you're telling the Home Office, yes, I'm one of these people, I've got to talk to you about my extended absence. So you're going to be proactively asked by the application, in which case you then obviously explain. People have asked in other questions I've seen about evidence. So you want to put forward evidence to explain if it's to do with work, to do with medical situations. That I may as well cover the questions about should evidence be in English? Yes, Home Office can't consider things that aren't in English. So if you want something that's not in English to be understood, then it has to be translated. This means a professional translation. It doesn't have to be signed off by a lawyer. It doesn't have to be attested by anyone, but it should be a professional translation if you want the Home Office to consider it. But the answer would be that you are explaining your situation in the application, you are providing the evidence, and hopefully by doing that, you're telling the Home Office, you're showing them that you meet the rules for having that kind of extended absence. If we go back to the one where it's the one that doesn't meet the rules because it's sort of multiple absences, but for an important reason, and it ultimately doesn't exceed 12 months, you still will be thinking about, in the future, I will probably be, when I'm engaging with the Home Office, obviously you're going to be the likelihood is the Home Office will be communicating with you saying, what's your situation? And of course, at that point, you'll be explaining, and the same applies to producing evidence and a good explanation. Always start with the idea that give a good explanation. What's happened to you? Why has it happened? Is there evidence that can back up what's happened? If like I say, if you're talking about overseas study, where's your records? Employment, what was your employer asking you to do? Medical records where appropriate. So always look to back it up, and always give a good explanation, because that's how you can show that what your extended absence has been caused by is reasonable, because that's what the rules are looking for. It's a reasonable justification.
And you mentioned the need for documents to be in English. We've had a question from Beatrice about whether or not translated documents need to be certified by a lawyer or not.
Yeah, so no, not a certification from a lawyer. The Home Office broad rule on this is that it should be a professional translation. So there are obviously agencies or professional freelance translators who can provide give you a document and sign it off as a professional translation. What you can't do if you want the Home Office to definitely consider it is you can't stick it into Google Translate and produce it. You can't do it yourself, even if your English is impeccable, because that's just sort of the Home Office approach to translations. If you have sometimes in the past people approach me and they have like 50 documents that are not in English. And I wouldn't always say to someone, right, let's translate every single thing here. It could be like 50 bank statements, but I might just choose the ones with the most key information to translate. So sometimes there is judgment here, because we don't want people to, have to get thousands of pages translated. But obviously, if it's a doctor's letter, which is 1 page long, it should be supported by a professional translation. Yes.
Thanks. And you mentioned the need to set out the reasons why your absences are reasonable. Rodrigo had asked how you go about justifying that. Do you provide, in the case, for example, of someone who's had an overseas posting for a while, is a cover letter enough to explain the situation plus an employment contract or pay slips
I would hope so, yeah. Exactly. So, overseas posting sort of for employment is one of the examples given in the rules. So if you can say this is why I was absent for, let's say, 11 months, and that's supported with a letter from your employer, or some kind of just something to back that up, there's no reason why you need to produce anything more than that. It's that clearly meets the burden of proof.
And can you tell us a bit about the circumstances in which somebody might be able to have two important reasons or two absences? This is something that Adam has asked. Is it very rigid, or can somebody have an absence for COVID-related reasons and then another absence? And how much discretion is there?
Yeah. Okay. So just to give I think it's better that I just explain what is meant by sort of two important reason absences. So when the scheme was originally agreed upon based on the withdrawal agreement between the UK and the EU, it's based on the Free Movement Directive, which allows for one absence, one important reason, extended absence, this single absence of up to 12 months within the 5-year qualifying period. So that was initially how the scheme was drafted. And then, of course, we had a COVID pandemic, and the Home Office had to kind of address the absence rules because, for one thing, people were being absent for more than 12 months due to the pandemic, and also someone who'd already perhaps had an absence for an important reason, let's say was studying overseas for 11 months, had already had that important reason absence, then they were forced out of the UK for a period because of COVID. It wouldn't have been fair for them to have sort of said, the Home Office said, well, you've already used your absence, extended absence allowance, and now COVID, well, that's just hard luck. So what the Home Office did was a very pragmatic kind of approach, which was, they said absences related to COVID could exceed 12 months. You have to kind of justify probably an absence that's gone over 12 months needs a bit more justification than an absence that's up to 12 months because of COVID, but it is possible to have an absence that exceeds 12 months because of COVID. And secondly, the Home Office said, well, if you've already had an absence because of an important reason, employment, posting overseas, and then you have an absence because of COVID, that is acceptable. Or it could be the other way around. You have a COVID extended absence and then you've come back, but then you may get posted overseas. You're allowed to do that. So the order in which your extended absences arise doesn't actually matter. But the key, as far as the way that the rules and the policy approach is done, is that one is related to COVID and one is related to something that's not to do with COVID. I've talked about overseas studies, overseas employment posting. So the idea is that you have sort of, it is genuinely, the pandemic is one of the reasons why you've got two extended absences. So that's how the rules have been sort of made more malleable to address the pandemic, and as we say, rightly so. So the question then comes down to how rigidly is that sort of distinction between absence number one is for COVID and absence number two is for something unrelated to COVID. And the answer is I don't think that I would have seen enough cases to know how rigidly the approach is applied. It's written that way for a reason, and you can understand the policy, because if there had been no COVID, then people would have only been given that one extended absence. So you can understand why one of them has to be connected to COVID. But like everything, it's really important when the Home Office looks at it, and goes back to that idea of explaining it, is that they kind of take into account all the factors. What is this individual situation? Why has it arisen in the way they've got two absences? How have they sort of arisen? Is it proportionate? Is it reasonable to say that fills sort of our policy objective, which is to not penalize people for having a second absence that's related to the pandemic? So I would expect people to be able to explain why one was COVID and one was something else. But I would also expect on the Home Office side them to approach it in a reasonable and proportionate way when assessing if someone is sort of within what their policy is intending to allow.
Okay, thanks, Chris. There's a question also about excessive absences, but where the excess is minimal. It's a question from Ronald that I'll read out. It said, I was 2 days over the allowable 180 days a year absence due to lack of flights post-COVID. So in this instance, he went out on the 4th of November and came back on the 4th of November 2020 and came back on the 6th of May 2021. And he's saying, can I move my pre-settled start date to a few days out so that I don't breach the 180 days? So for example, if he applied for settled status, imagining that his residence started on the 6th of November 2020 and not the 4th of November 2020, is that something he'd be able to do?
Okay. I mean, a few things to unpack here. First of all, because we're talking about 2 days over a 6-month absence, but related to the COVID pandemic, you're not constrained by a 6-month absence because of that, because you can have, well, you can at least definitely have up to 12 months. You may be able to go over 12 months because it's to do with COVID. So someone saying I was absent for 6 months and 2 days because the pandemic meant that I couldn't fly back when I wanted to falls within the Home Office policy on extended absences to do with COVID. So first of all, Ronald, you don't have to worry about your situation. You don't have to move anything about. You just have to say if everything else is in order with your settled status application, you can say, yes, I have an absence that was over 6 months. Was it to do with COVID? Yes, I couldn't get a flight back. That's well within the Home Office policy. So you're not breaking your continuous residence. If it was a situation where someone said, I was on holiday, so nothing to do with important reasons, although holidays are very important to us, they're not considered to be important reason absences. So I was on holiday, I got my dates wrong, I booked a flight back 2 days after my 6-month, very nice 6-month long holiday. So it turned out I had a holiday of 6 months and 2 days. I'm going to go back to my answer about the rules being binary, because that does exceed the allowance that you're given, which is the 6 months in a 12-month period. Can you move your residency period? No, because you would be outside. You cannot start a residency period when you're not in the UK. Your residence period is always triggered by you stepping foot in the UK. So saying, well, can I start my residence period when I was 2 days into my holiday? No, you can't do that. So in that scenario, if you had a holiday for 6 months and 2 days, you can't rely on the important reason for an extended absence. You can't meet the rules to be resident or to meet the 6-month in 12-month rule. So you couldn't apply to move from pre-settled to settled status. But then you go back to this question, is it proportionate for someone to lose everything under the scheme, to have their status taken away because they breached the rules by 2 days? And if you're asking me that question, I'd say, of course not. Like, that doesn't seem like a proportionate outcome. But you're not applying for settled status in that scenario because you can't meet the rules. You're wait and see. Let's have a look at the Home Office, approach to these types of situations. So yeah, that's how it would work. If you were talking about 6 months, a little bit over 6 months, but it can't be justified under the important reason clause.
Okay, thanks. I'm going to ask some questions about automated extensions, which I think we've touched on already, but Thess has written in saying, for people who've got pre-settled status and are currently in the UK, but left for more than 6 months, and haven't accumulated 5 years, are they likely to still have their pre-settled status automatically renewed and extended?
Yeah, so this goes back to Kezia's introduction, in that the Home Office policy at the moment is you are coming to the end of your pre-settled status, everyone. You've obviously not got settled status, and therefore we will extend automatically your pre-settled status. Nowadays, that extension is for 5 years. So that is what happens for everyone who has pre-settled status, or it should happen for everyone. If it doesn't happen, you need to if your pre-settled status, if you're coming to an end and it doesn't get extended, you should contact the Home Office Resolution Centre, because there's been a glitch, there's been a problem. The 3 Million has an excellent tool to report issues to do with digital status, because of the wonderful work on advocating for improvements about digital status. But in theory, everyone's pre-settled status gets extended automatically when the system works as it should do. And as Kezia said, the Home Office is not saying we think that you're entitled to this pre-settled status extension. They're saying they're not telling you anything about your situation except that their system acknowledged that you were coming to the end of your normal your first 5 years of pre-settled status, and you need to be extended because you can't lose your status without someone making a decision to take it away. So everyone's pre-settled status gets extended. In this scenario, where we're talking about someone who is close to sort of 2 years absence, so even though they'll get the 5-year extension, we know, what we understand from the Home Office is that at some point that person is going to be communicated with by the Home Office, because they will need to explain why they've got an absence of nearly 2 years, because the Home Office has to decide whether they've broken their continuous residence. And so that's when the kind of crunch moment comes, in terms of the Home Office saying, right, now we need to understand if you've maintained continuous residence. We know we extended your status, that's because that happens automatically, but now we want to understand more about your residency over, this period of time. But yeah, so the simple answer is the status should get extended. The more complicated aspect is when someone does have an absence that's creeping up to 2 years, the likelihood is in the future the Home Office is going to want to understand what's happened, and probably will have in their minds that that's someone who has broken continuous residence. I'm not saying they definitely have, but that will probably be the Home Office thinking.
And so this relates a little bit to a question that we had from someone called Thea about whether or not, if that is an issue for somebody, this question about excessive absences, are they likely to have their pre-settled status cancelled or curtailed, or will that just happen at the point at which they would apply for settled status?
Yeah, so as we just said, in terms of knowing whether your pre-settled status should be extended, the current policy is just based on you coming to the expiry. Yes, you will get an extension. So that's the sort of first part. If you applied for settled status off your own sort of volition, and the Home Office says you don't meet the rules to get settled status, they do not cancel your pre-settled status at the moment. They don't cancel pre-settled status. If there's a kind of conduct issue, they might do. But if it's just about you can't have settled status because you don't meet the residence rules, the outcome says you don't get settled status, but the Home Office doesn't cancel your pre-settled status. They leave it intact. It's extended if it needs to be extended because it was coming to the expiry. So really, the moment where someone might be engaged with in the future about whether they've met the residence rules is when the Home Office when they decide what their policy looks like, and when they decide to operationalize whatever policy. And at the moment, we just don't know when that is. There is, as Kezia again said, the Home Office later on in this year is looking to sort of expand the automation process. So maybe in line with expanding the automation process, we'll have some kind of understanding of what the status removal process looks like, but we just don't know at this point in time. But essentially, yeah, people are being kind of left in a little bit of limbo in terms of the automation of pre-settled status. It happens, it's automatic, and the Home Office is saying at some point in the future we may communicate with you about your situation to decide whether we really think you should be entitled to it.
And this question about how long people get as an extension of their status is something that's come up quite a bit in the questions. So some people, of course, will have got the 2-year extension. Some people will have got an extension of 5 years. And we've had a couple of questions about this from Andrea and George asking what happens to somebody who's received a 2-year extension? Are they then going to get an additional 3 years on top of that, or a 5-year one after that? There seems
it's a really good question. I guess people with 2 years feel sort of shortchanged once the Home Office extended to 5 years. But you sort of, what you have to understand this aspect of it, you need to understand why is the Home Office extending everyone's pre-settled status without question, because that's really what this comes down to. And the Home Office, as far, or my interpretation of what the Home Office is doing, is they're saying, well, right now we don't have the ability to look at people's individual situations, and therefore we're extending everyone's pre-settled status so that we can get a policy in place, we can operationalize what will no doubt be a big policy. There's still a lot of people with pre-settled status, so there's a lot of work to be done in terms of understanding who may be moved to settled status and who might have their pre-settled status removed. Obviously, because you talked about the 3 million position, which would be a far simpler approach. But assuming the Home Office is going to engage with people in the future about their pre-settled status, it's a lot of work. And so from the Home Office perspective, what they have to avoid is people's pre-settled status just expiring, coming to an end, because that's what the IMA, the Independent Monitoring Authority judgment that Kezia talked about, that's what it says cannot happen. You cannot just let people run out of status. So initially the Home Office said 2 years. They thought that was enough time, I guess, to start to look at the bigger picture, and they've now extended it to 5 years. Maybe that's a kind of like a sort of an implication that it's going to take a bit longer. So if you've got 2 years and you're coming up to the end of it, I think the first 2 years would start to run out in September 25. So we're not there yet. If we get to September 25 and the Home Office policy is the same as it is today, then my understanding is you would just get a 5-year extension on top of the 2 years that you've already had. Because the Home Office would have to avoid your pre-settled status expiring, and the way they currently do that is to give people 5-year extensions. So they wouldn't give you 3 years; they would just give you 5 years. That's how I understand it. I mean, obviously, if there's a difference in approach, I would expect the Home Office to publicise this, but that's how I would see it happening. So you could, in theory, end up with sort of 7 years of extensions, but as we say, and we're going to sort of consistently sort of talk about this and come back to it, the Home Office is potentially going to approach people at some point and say, what is your resident situation? We need to look at whether you're entitled to these extensions. So it seems unlikely, if that's the Home Office policy, that someone will be allowed to continue for 7 years of extensions with pre-settled status. That would go against the idea that the Home Office wants to understand people's situations in a bit more detail. So yes, the extensions will be granted in that scenario. 2 years becomes 5 years at the next extension, but also there's the possibility that the Home Office policy on engaging with people will start to be implemented. It could be this year, for all we know. It could be next year. So yeah, so that's how I understand things to work for people with 2 year. And obviously, sorry, the other thing, just to add to that, is if after the 2 year extension someone met the criteria to be automatically granted settled status, I would anticipate that happening for them. So obviously, there's some people who might just get moved to settled status, which would be very, very good outcome for them.
And we've had a question in the chat on this from Alban, asking for some clarity about whether the automatic extensions are happening now for non-EEA nationals as well.
Yes, they do.
But not the automatic upgrades.
No, as you covered again at the beginning, because so just to understand why, it's because so at the moment the Home Office, for automatic upgrades to settled status, they're using a national insurance number. So someone who is a non-European family member might say, well, I've been working for 5 years, I've got 5 years of national insurance records, upgrade me, that would be fabulous. But because you're connected, at least at some point you were connected to a European sponsor, the Home Office needs to understand your situation with respect of your sponsor, and so that would involve a human caseworker, and so is not part of the current automation process. So that's why it doesn't happen for people who are non-European family members, or were non-European family members.
Whereas with the extensions, it's all automated anyway because there's no consideration of your ongoing eligibility.
Exactly. Thank you for, yes, exactly.
Thanks. Hopefully that's clarified that issue. Some other questions about automatic upgrades. Ursula has asked, what happens if you're not eligible for an automated conversion to settled status because you live here but you don't have a national insurance number and have never worked here? What happens then? You just have to apply for settled status.
Yeah, so if you know, if you know that you can't be automated under the current policy because let's say you've never had a national insurance number, or you've had one but you've not worked because you've been doing other things, and so and not claiming any benefits, so you've just got a non-active national insurance number, or you don't have one at all, you know that you cannot be currently automatically upgraded to settled status because of what we've explained about the current process. But if you've completed a 5-year qualifying period, because and to be clear, I hope people have we've been clear about this, but not being upgraded automatically to settled status says nothing about whether you're eligible for settled status. It just says you don't have the HMRC, the national insurance records that the Home Office is looking for. So plenty and many people, and maybe even more people than those who will be automatically upgraded, will not get automatically upgraded under the current approach because they don't have complete national insurance records. So if you've got your 5 years of residence, but you're not going to get automatically upgraded, then you can apply for settled status and you can produce the documents to show that you've been living in the UK for the 5 continuous years, bank statements, tenancy agreements, mortgages, university documents, whatever is your situation, you can apply. And you should get settled status if you can prove your 5 years of residence, and the Home Office caseworker should work with you to get you to settled status by asking you if you need to fill in gaps in your evidence, to ask you clearly what they need to see. So yeah, you can apply for settled status. You don't have to, because your pre-settled status will be extended and it won't expire. And down the line, again, as Kezia has talked about, the Home Office is looking to use different data. We're thinking border data here to maybe upgrade people who haven't got the national insurance records. And so you could wait and see what happens under that process, because hopefully that will benefit people. But I mean, if someone said to me, I've got the 5 years of residence, I've got the evidence to show it, should I apply? I would say it's free to apply, and it should get you to settled status, and that's really what you want because that's your security. So yeah, so that's
and if it doesn't work, if you apply and if you apply and it, as you say, it's free and it doesn't work and your application's refused, what can somebody do at that point?
So if your application for settled status is refused on the basis that you don't meet the residence conditions, I'll stick to those types of refusals. Then, well, if someone came to me and said, I've been refused, I've been told I haven't proved the residency, the 5 years of continuous residence, I'd look at what was submitted, and then we would decide what to do. Like, because it may be that the person has other evidence of the residence that they didn't think to submit the first time. They thought maybe I had enough and it didn't turn out to be enough. So sometimes you might want to go back and make another application. You're not prevented from making a second application for settled status with improved evidence. If someone said to me, I've got all of the evidence that I can, and it's still not enough for the Home Office, then we might say, well, I think an immigration judge, you have a right to appeal that Home Office decision. An immigration judge might take a little bit more of a pragmatic view and a bit more of a flexible view about what evidence you've had. We want to know, what are you missing? Why are you missing some evidence? Lots of people have good reasons for not having a complete set of evidence. So it might be something that should be appealed. Or we might say, well, I don't even think that maybe a judge is going to be sympathetic for whatever reason. In that scenario, I might say, well, let's wait, and now we wait and see what the Home Office policy looks like, about removing status, and because it might be that actually it becomes a bit more flexible about moving people from pre-settled to settled status in the future. So I might say, again, wait and see for some people. So it would depend on exactly why the Home Office says you haven't shown us that you've got a 5-year residence period. because there will always be different situations which call for different approaches.
Thanks, Chris. What would happen to somebody who, we've had some people contacting us who've actually had really, really long absences from the UK, who've essentially left the UK, who were here, say, from 2020 till 2022, and then perhaps left and moved to another country, but who've received an extension of their pre-settled status. What sort of situation would they be in?
Yeah,
They-
I mean, these are definitely going to be the more difficult situations, and the ones where there's the biggest risk of having status removed is where where someone looks like they have broken their continuous residence due to a pretty long absence, and that it might not be disproportionate for the Home Office to remove the status. I mean, proportionality is a very broad concept in terms of when we're talking about removing someone's right to live in the UK. So it should be applied broadly, but the Home Office starting position is likely to be you were given pre-settled status with an explanation of what that meant for you, and that you know, if you wanted to progress to settled status, there were some residence conditions apply. I think that some people very arguably feel that the letters they got with the pre-settled status grant didn't always make it as clear, or wasn't as clear as it could have been in terms of what needed to happen to move to settled status from the residence conditions perspective. But the Home Office would say, we told you what you needed to do to remain resident for your 5 years to get to settled status. If you have then voluntarily had an absence of 2 years from the UK, that's entirely your choice, but you can't now progress to settled status. And the fact we've given you an extension to your pre-settled status is not offering you the chance to start again. We're not offering you the chance to start another 5 years from when you came back to the UK after your 2-year break. We're doing it because, as we've sort of emphasized, it's done automatically, not because people meet the conditions and not because people are allowed to start a new qualifying period to build up to settled status. So someone with that kind of absence is at probably going to be at quite significant risk of having their status taken away in the future. But I don't know what the policy looks like, and it will potentially depend on how long they've been back in the UK. What have they been doing? How integrated are they? There's all sorts of factors that could come into whether or not it is actually proportionate for them to lose their status. But the Home Office starting point is likely to be you've broken the residence rules by quite a big way, and so we're now going to look to take away your status, to take away that extension. We didn't give it to you so you could start a new 5-year qualifying period.
And so if somebody, we've had two people messaging us about points that touch on this. It's somebody in that situation, let's say, who left the UK, had a very long absence, is still abroad, hasn't returned to the UK, but has received an extension of their pre-settled status, much to their surprise, perhaps.
Yeah.
If that person is looking to now re-enter the UK, either to take up a job offer or a university placement, are they entitled to do that with the pre-settled status extension they've got, even though they know that they've actually been away for a period that would be considered excessive?
Yeah. Okay. There's a slight complication to answering this question because of the rules on lapsing status, which were that it lapsed at 2 years. So if I put that aside for 1 second, so if someone has status hasn't lapsed under the old rules, but they have got this really, so they've got this long gap, but they still held pre-settled status and were given an extension of, let's say, 5 years to that pre-settled status. You can use that status. It's legal status. You can come to the UK, you can work, you can study, you can rent property in England and anywhere else in the UK. I only said England because landlords check your status in England. You can do all those things because you've been given an extension, and there are no conditions attached to the extension. the conditions come if the Home Office looks to take it away. And so what you need to be very clear if you're in this situation, that you can use that status as long as it's valid. And if you want to do things, if you want to come and, let's say you're thinking, oh, maybe I'll come and work for a year in the UK, you can use the status to do that. But you have to be aware that from if you're on this call, that the Home Office might approach you because you're someone with pre-settled status, and they certainly wouldn't be able to move you to settled status, I would think. So they would potentially at some point approach you and say, we need to understand your residence position. And of course, then it goes back to and they're going back to the end of 2020 when they say, we need to look at your historical residence period. And that's when it might be a case of, well, you've had too long. We don't think it's proportionate to take away your status. Yes, you can appeal that decision, but our final decision is you're going to lose that extension because you didn't meet the conditions. So everything that's happened to you up to that point is entirely lawful, but your future becomes very uncertain at that point, because you would have to appeal and have a judge overturn the Home Office decision, and it probably wouldn't. It seems like it would be unlikely a judge would necessarily do that. So yes, you can use the extension, but you know that your future is not secure just because you've been given that 5 years.
And so George asked a question, so firing them all at you here, Chris. It's just gone 7, so we've got another 15, 20 minutes of questions. I'm afraid we're not going to get through all of them because they're piling in, but as we said, we will put together a Q&A document that hopefully will be helpful for those of you whose questions aren't answered in this session. But George had a question that follows on from what you've just been saying, Chris, which is whether somebody who has previously had pre-settled status and lost it because they didn't maintain their continuous residence would be able to seek to reapply as a joining family member and re-enter the UK that way.
So it's a good question. I mean, obviously, to qualify as a joining family member, you need an eligible family relationship and you need a European sponsor. So this is not going to be a solution for anyone who doesn't fall into that category. But yes, if you've broken your continuous residence that your initial pre-settled status was granted on, and you're fortunate enough to have someone who can sponsor you as a joining family member, you can apply under that category and obviously joining family members, because joining family members are not required to be present by the end of 2020 and maintain continuous residence from the end of 2020. Joining family members are allowed to come at any time as long as the family relationship is covered by the settlement scheme. So yes, in that scenario, he could come, he could start a new period of pre-settled status as a sponsored family member and build up 5 years from whenever he arrived.
And would he have to leave the UK, or could he put in that application whilst still here?
My view would be there's no reason why he couldn't apply from the UK, because in that scenario, because he's already got the existing pre-settled status, but he knows that he's broken continuous residence. And I would say this is only something right now to be thought about by people who are genuinely sure they've broken their continuous residence, because there's lots of like question marks people have, like, have I broken my continuous residence? But if you know that you've broken it, if it's really like we're talking about a long absence, but you've still got your pre-settled status and you're living here now, my view is there's nothing wrong with. I can't see how you can't meet the joining family member rules, and because you've got pre-settled status, you're not deemed to be a late applicant under the settlement scheme if you're present in the UK. So I feel that you should be able to move and say, I want to move into this category. I've got my pre-settled status already, but I know that I'm not going to move to settled status under this grant. I want a grant in the joining family member category. So there's nothing. I don't see anything that forces the person to leave in that situation.
Thanks. That's really interesting. So Ronald has asked, at what point would be a good point to apply for settled status for someone who hasn't necessarily or hopefully broken their continuity of residence. If they're planning to leave the UK on holiday shortly after applying for settled status without having received a decision, are they going to have problems getting back in? Would it be better to wait until they've come
Um,
back?
so the settlement scheme, the way it operates is you don't have to remain present in the UK whilst you're waiting for an outcome. If you're making and in this situation we're talking about moving from pre-settled to settled status, so your pre-settled status it remains intact whilst your settled status application is being considered. As long as you know that if you know you've completed your 5 years, then that's fine, because once you've completed your 5 years, what happens after that is not relevant to your application for settled status. It doesn't really matter unless you were going to have 5 years outside the UK, but we're not really talking. That's quite an extreme situation. So you've completed your 5 years. You can apply on the day you complete your 5 year qualifying period. You apply for settled status. You can go on holiday. You can. You shouldn't have any problems. The Home Office will process. They'll contact you if they need more information. There is a little bit of a problem if you change your ID document during this process. This is not really connected to the talk that we're having tonight, but there is the Home Office. We understand it doesn't allow you to update your if you get a new passport. If they don't allow you to update your profile if you've got an application under consideration. So I guess if someone said to me, I know that I'm going to leave on one passport and I'm going to have a new passport when I come back, I would probably say wait until you've got your new passport, upload it to your UKVI account, and then make your application for settled status. I would probably say that, but that's quite a niche situation, I would think. But no, you can apply, you can leave, you can return. Your pre-settled status stays intact whilst the Home Office is looking at your settled status application.
And how long are applications taking at the moment? We've had several questions on this from Thibaut and Luis, being two of them, asking about how long people need to expect to wait for an answer on this. A lot of people found that when they made their initial applications for pre-settled status, they got answers straight away or within a very short time period. And now, of course, we know that people are having to wait a lot longer. So we've had several people saying, I've been waiting for months. I've not been contacted. Should I be worried? How long is it? How long should people expect to wait?
Yeah, I mean, it's a good question. I mean, there is no like set processing time under the settlement scheme, and so that has led to some quite sort of variable outcomes for people. Like as you say, initially grants of status were made very quickly, particularly for pre-settled status, because it doesn't require as much evidence as it does to get settled status. So the Home Office sort of indicates it might take over a month if they're looking at evidence. If you have a complete national insurance record, then it shouldn't really take a long time. But if you don't have a complete national insurance record and you've had to submit documents, or the Home Office has had to ask you for more documents, then it will take longer. I feel like we're now looking at several months. I've certainly been contacted by people who recently who are sort of a bit like concerned, and it didn't concern me from what I know, because it wasn't like we weren't talking about 12 months here, but we were talking about sort of 4 to 5 looking into 6 months. And so that seems to be something that's not exceptional necessarily. I mean, it's hard to know because there's no data on this, just to be clear. It's that I know that the 3 million is always trying to get this data from the Home Office through Freedom of Information, and so you try to get that out there, but it's not known, just to be clear to people, how long the average processing time is generally. So, but yeah, if you have the confirmation it's been submitted, then it will get considered. I mean, that's the thing to remember is if it's with the Home Office, they will process it, they will give you an answer, they will communicate with you. And obviously from your perspective, once you've made your application, or make sure your UK visa and immigration account has your correct email address, has the one you want to use, has your right telephone number, because the Home Office will use that email address to communicate with you. And obviously check your email, check your spam folder. We know it happens. Communication goes into there. So generally speaking, it will just be that the Home Office is processing it. But in some cases, it might be actually you've had your outcome and it's been sitting in a junk folder for 3 months, and actually you didn't get the good news, hopefully, as when you should have had it. But yeah, so don't panic. The months for some applications for sure.
Thank you. And if somebody, another question about what happens if someone's status has expired, rather than being able to come in as a joining family member, Ursula has asked, would it be possible to apply for an ETA, an electronic, the electronic travel authorization that applies to visitors to the UK if you've had pre-settled status before and it's expired, or if, for example, you've had a refusal of a settled status application, possibly because you've had excessive absences. Is that going to make it more difficult for you to come back into the UK as a visitor further down the line? Is it going to stop you getting an ETA?
Yeah, so at the moment, I guess like I wouldn't talk in terms of pre-settled status expiring because it shouldn't happen. So even if you've been turned down for settled status, as we've sort of said a few times this evening, the Home Office does not take away your pre-settled status. It carries on and is extended if it's coming up to the expiry date. So in terms of people shouldn't have that experience of pre-settled status expiring right now. But let's take the situation of someone definitely broke continuous residence. In the future, the Home Office takes away their pre-settled status, and that's the correct decision. Will they be able to get ETA to visit? That would be to visit. That's what electronic travel authorization is for. Yes, there's no reason why they shouldn't. The only reasons people would be refused electronic travel authorization is due to suitability issues, and by that we mean criminal offending, breaching immigration laws, potentially sort of having bad character associations in some cases. So yeah, there shouldn't be a reason why someone, if in the future the Home Office says you're no longer eligible for your pre-settled status, you've broken your residency, and that's the proportionate outcome is for you to lose that status, you should be able to get ETA. If you have ever had a settlement scheme application refused on a suitability basis, like a criminal conduct issue, or lost your status because of a criminal conduct issue, that will likely mean that you're not going to get an ETA, because the ETA has quite strict requirements on criminal conduct and things like that. But that will be a very minority of situations.
And thank you for clarifying that again, that your pre-settled status can't simply expire. But if, for example, you had been outside of the UK for many years and it had lapsed, so you'd been outside long enough for your leave to lapse. Bernard Ryan is asking in the chat, what actually happens to somebody in that position legally? Do they receive a notification of the fact that their status has lapsed? There's no cancellation or curtailment decision, and presumably no right of appeal against that. What does someone do if they find themselves in that position?
Yes, it's a very good question, which certainly doesn't have an answer from the courts that I'm aware of. So I think if I was looking, I think that the now that the lapsing does not happen until 5 years, I think that's if your status lapsed after 5 years, then maybe there's a different situation than these earlier cases where status lapsed under 2 years, maybe not. But if someone approached me and said, I was away I had pre-settled status, I've been away for 2 years. I was away for 2 years before the 21st of May 2024, when the law changed and extended the absence allowance to 5 years. So I know that this law says that my pre-settled status has lapsed. Is that correct? My view would be no, it's not correct, because the withdrawal agreement between the UK and the EU, on which is what your pre-settled status is based on, doesn't allow a situation where status can just vanish like that, because you're entitled to a decision that takes away your status. You're entitled to a right of appeal against that decision, and you're entitled to know the reasons why your status has been taken away. So none of that happens under the lapsing leave, the rules that apply to status just sort of being taken away if you're away for more than 2 years. So none of those procedural things happen. So it seems to me that there's a very strong case to say that that is not how the withdrawal agreement operates, and therefore, when there's a situation where UK domestic law conflicts with the withdrawal agreement wins, and it trumps, and basically the domestic law is disapplied. So I might say to someone, if they approach me and wanted to understand their position in the courts, that I would say, well, you would potentially argue that your status has never lapsed. I would say one thing about that. So that's how I would look at it technically. I would still have to be very aware that the person would be at risk of having their status taken away for an absence that's gone over 2 years, because they've been away for quite a long time. So even if you could win the argument on the technical point that your status didn't just sort of vanish, you could win that technical point and still have your status taken away by the Home Office because you've broken the residency conditions by quite a significant amount. So, but it's very technical, it's very complicated. But that would be my view. And as I say, it's untested, so I'm not for 1 second saying I'm right. But that would be how I would see it.
Thanks. And another question, Chris. We're getting close to wrapping up here, so just another couple of questions. There was a question, an anonymous question put in the chat about what happens to somebody who has pre-settled status and wants to make an application under another route. Can retaining pre-settled status, and I suppose the extension as well, count towards ILR routes on other immigration routes? Can somebody achieve settlement outside the USS relying on their pre-settled status?
Yeah, so the broad answer is yes, but there's sort of, again, there's a little bit to unpack. So when you have like pre-settled status, so you have it's UK domestic immigration status, that's what it is. So if you identify another type of immigration route, that's what we kind of lawyers talk about, like, so there's like skilled worker rules, there's rules for students, and there's different types of visas. So if you identify a different immigration category that you qualify in, you can make an application to the Home Office and say, I have pre-settled status right now, but I want to move into this other category. Because in your head, you don't tell the Home Office you know that you're never going to get to settled status. You just say, I want to move. But in your head, you're moving into a different category because you're aware that you might not get to settled status. And so this is only for someone who's definitely really convinced that they're not going to get to settled status. So if you meet the conditions to move into that alternative immigration category, then you can do that. I mean, you can always check that immigration categories tell you if there's a status you're not allowed to move into them from, but I'm not aware of any preventing you with pre-settled status, or the most of them wouldn't prevent you with pre-settled status from moving into them. But you want to be sure that you qualify in the category you're moving into, because you will have to pay the Home Office, because almost everything else in the immigration system is paid for, and also paying the NHS charges that you have to apply with. So, so yes, it can be done. Does the time spent on pre-settled status count towards qualifying for indefinite leave settlement on that route? Probably not. It will depend on the route. So not every immigration category allows you to settle, so you need to check that as well. So there's lots of things to factor in. Mm-hmm. But the broad principle, sorry, I'm going to have to take a drink in a second.
Have a sip. Yeah.
The broad principle is you can move. Excuse me.
Thank you. Okay, I think we really are coming to the end. So we've just got a couple of questions that have come into the chat that touch on a similar topic. So while you're having
I think I'm okay.
sip of your water, I'll ask you these two questions together. There was a question from Anonymous, which was, how does an EU sponsor's absence affect a non-EU national dependence settled status retained rights application? after divorce. And the second question from William Sanko was, what if the non-EU, yeah, a similar question. What if a non-EU family member, sorry, no, what if the non-EU family member's EU sponsor, EU national sponsor, has left the UK? Will they be eligible for settled status?
Yeah, okay. So the first one, when we have a divorce situation, there are rules within the settlement scheme that so obviously the general principle is if you're a non-European family member, you're being sponsored by a European family member who has status under the scheme. So in the most simple scenario, you've got 5 years of qualifying residence as their family member, you can get settled status. If you have a divorce during that your 5 years of qualifying as the non-European for settled status, that's going to have an impact because you're losing your sponsor because you're no longer their family member because you're divorced. There are some rules within the settlement scheme that say even though you are no longer the family member of your European sponsor, it is appropriate for you to retain your residency in your own capacity. And there are different situations where that can arise. It can be due to the length of your marriage before the divorce took place. It can be if you have custody of children who you are caring for. It can be if there is situations of domestic abuse or violence. So there are different types of situations where a divorce may mean that you can still keep your right of residence in the retained category. So you're looked at differently, but the ultimate point is that you can still continue your residency and move on to settled status. If you don't meet those conditions to retain your right of residency in your own capacity, then you become at risk of the Home Office removing your status because they would say, well, you were here conditionally because you were the family member of a European national. You're no longer that family member. You haven't got 5 years of qualifying residence as a family member. Therefore, you no longer meet the conditions of your settlement scheme status. You've got pre-settled status. You no longer meet the conditions. So we are now going to take that away. So those are decisions that do happen today, to be clear. So everything we've talked about removing status in terms of breaking residency, none of that happens in theory at the moment because the policy to do that isn't being agreed upon. But there is a policy to remove people's status if their family relationship has broken down and they do not have what's called a retained residency right. And the Home Office does write to people, non-European family members, and says, we're going to take away your status because you no longer meet the conditions. Now, the Home Office is supposed to take into account the proportionality of that decision because that's a requirement, is to look at the whole picture. And I think if you talk to organizations who deal with these types of cases, they would probably argue that the Home Office, in their view, doesn't do a great job of assessing the proportionality of removing status and that people are getting some pretty tough decisions on that basis. So it's a complicated area. If you are someone in that situation, then very much, as Kezia said at the top, need to get that legal advice, speak to someone who understands, because you need to know if you might have the right to keep your status in your situation, even though you've lost your family member. And if you haven't, you need to know what are the implications. How is the Home Office potentially going to attempt to remove my status? What do I need to tell them about my situation to make sure that an appropriate decision is arrived at? So they are difficult situations. The second question was about if you just have a situation. So I think what we're sort of talking about, say you have a couple who are married, European, non-European, they're still married, there's no issue, there's definitely still family members, but the European sponsor, husband, wife, leaves the UK. Where does that leave the joining family member? And it's definitely it's a confusing one. Again, so the starting point, what you would like to see is if the non-European family member has been living in the UK as a family member for 5 years, then obviously they've got their 5 years. Once you have your 5-year residency as a family member, it's in the bag. So the fact that your sponsor then leaves doesn't affect you because you've got your 5 years you need. You can move to settled status, even though your family member is no longer present. If you have pre-settled status when this happens, and you don't have 5 years of qualifying, it's a bit. I don't. It seems to me that it's pretty clear. There will be a risk that the Home Office will say you have not completed 5 years and you do not have a sponsor, and they've left the UK. That seems to be a risk that would happen. How the Home Office would understand the situation and the information about both parties is a different question. So, yeah, it's definitely a complicated area, of which I've not seen. It doesn't. It's not something I've seen, so I
I
can't
suppose it would
sort of
arise more commonly, maybe not with a couple, but with another type of joining family member.
Say again, sorry.
Might be more common, not with a couple, but where the sponsor was a different type of family member. Perhaps.
Yeah, I mean, I think ultimately we're talking about the family member hasn't built up 5 years of residence as with their sponsor with them, and you would think that like the intention of the scheme and the withdrawal agreement is for the sponsor and the family member to be in the same country. That sort of is how it works, but it might be that there's some technicality. So I think it's something that we'll have to revisit, and I'm very conscious of time. So thank you for a real brutal question at the end there.
Yeah. But I mean, thank you so much, Chris. It's really helpful hearing all of your answers to these questions. I hope that people feel that they've got that they're going away from tonight with some more information than they well, certainly with some more information, but with some of their questions answered. But of course, I think this last question really highlights the need to seek immigration advice, as Chris has said, as I said at the beginning, if you're in any doubt, because a lot of these rules are really complicated, and there's often it's often very difficult to give a kind of blanket answer, isn't it? So if you're in doubt and any of these issues apply to you, please do speak to an immigration advisor. As I've also said a couple of times, I'm conscious that there are lots of interesting, very relevant questions that we've not been able to address. We will do our best to address them and to send out the answers to you in due course after today's session. Andrea has put several links there in the chat, which hopefully will be of interest or of help to you. So please do take a look at those links before you leave. I think Andrea is also going to spend the last couple of minutes, and it really is just a couple of minutes, talking about the peer support group that we've got. So thank you, Andrea.
Thank you, Kezia. Good evening, everyone. I think we've really heard tonight from your questions just how much uncertainty there is around absences. And as we speak to more and more people, it's clear how this is already having a significant impact on our communities. As Kezia mentioned, the 3 million, we're urging the government to take a really compassionate approach and grant people settled status on the 5-year anniversary of their pre-settled, even in the case of absences. We're also really conscious that given how long it's taking for this policy to be implemented, even people who lived the UK for a few years in the meantime have returned and have established full lives here. And there are so many different life circumstances that lead to people being away for more than these 6 months that are allowed in the scheme. And we believe that people that have made their lives in the UK should be welcomed and encouraged to live, continue to live here, because this is where our home is. So this is why we're organizing a peer support group for both EU citizens and family members who have broken their continuity of residence or have questions around whether that is the case for them. And the aim of this group is really to support each other, to find that solidarity and compassion within one another, and potentially safe ways of sharing the potential impact that a harsh approach in this policy area would have in people's lives. So sharing that with decision makers. The first meeting of the group is on next Monday from 6 p.m. on Zoom, and you have more details in the chat. Even if you can't join that session, you can reach out to us and find out more information and express your interest. We're really aware this is an important time to not be alone and really find power in each other and ways of sharing safely stories and voices on this issue. So a really big thank you to both Chris and Kezia for talking us through so many questions tonight. We'll circulate both the recording and the full Q&A document with you in following the webinar. And a big thank you for all of you for showing up tonight and sharing your circumstances and your questions, and for supporting the 3 million. Good evening.